Hi everyone, I'm Orient. With the other group mates, we're going to present a case of Legal Services Commission and Fraine. This case took place under the jurisdiction of Queensland, and equivalent NSW legislation and solicitor rules are provided in the bottom left of your handout. The Legal Professional Act in Queensland will be abbreviated as LP Act in the following presentation.
Anthony Fraine was admitted to the legal profession in New South Wales on 6 October 2006. He also held an unrestricted employee practicing certificate in Queensland and was an Australian legal practitioner as defined by Section 6(1) of the LP Act. From around December 2020, Fraine represented Mr. Cameron Cusack in criminal charges related to using a carriage service to make a threat. During this period, Fraine made several unprofessional comments on Facebook, like, "Any of Cameron's carriage mates, go check on him please. This took his phone," or "keeping the boy out of jail," and so on, which might violate ethical standards and confidentiality obligations. Specifically, he revealed case detail by discussing the specific details and progress of Cameron Cusack's criminal case, which is a clear breach of confidentiality. The tribunal found that Fraine's conduct on social media breached Rule 5.1.2 of the ASAR and the standards of professional conduct expected of Australian legal practitioners. The tribunal took into account his various special circumstances and finally gave him disciplinary actions.
The law of lawyering in this section will be identify the legal and ethical principles relevant to the misconduct and reasons for the determination of UPC. Firstly, the comments Fraine made has reviewed the case details in progress. This was disclosed to social media that the other party is the subject of criminal proceedings. In addition, the specific detail discussed in the Facebook post were in relation to a client's criminal law matter on social media. The series of conduct constituted the violation of Solicitor Rule 3, which emphasized the duty to administration of justice, and Rule 9.1, which stipulates that a solicitor must not disclose any information which is confidential to a client. Secondly, Rule number 28 indicates that a solicitor must not publish or take steps towards the publication of any material concerning current proceedings, which may prejudice a fair trial or the administration of justice. Fraine made comments on Facebook and publicly identified and criticized in both parties, which violates the rule. After setting out the factual circumstances, tribunal considered the respondent engaged in conduct which is likely to materially degrade to bring the professional into disrepute, which is in contrary to the Solicitor Rule 5.1.2. The rule indicates that a solicitor must not engage in conduct which demonstrates that the solicitor is not a fit and proper person to practice law, or which is likely to a material degree to diminish the public confidence in the administration of justice, or bring the professional into disrepute. Subsequently, the tribunal went on to provide reasoning according to the relevant LP Act provision. Firstly, the Section 420 indicates that the conduct contravened relevant law which is capable of constituting UPC or PM. Furthermore, in determining whether the relevant conduct amounts to UPC or PM, reference is made to a number of cases. The first case, Legal Services Commissioner and Laley and al., which set out that the test required to determine whether conduct is UPC. The relevant falling short does not embrace all cases of error, but must be sufficiently substantial. There must be an appreciable departure from the standard for the conduct to be UPC. An isolated instance not involving unethical conduct and more in the nature of conduct which might give rise to an assertion of negligence is less likely to be UPC. In the second case, Legal Services Commissioner and Bradshaw stated that in establishing whether conduct is UPC, it refers to what a member of the public is entitled to expect of a reasonably competent Australian legal practitioner. And in the last case, and Queensland Law Society Incorporated, which outlined the test to be applied is whether the conduct violates or falls short of, to a substantial degree, the standard of professional conduct observed or approved by members of the profession of good repute and competence. The decision of UPC is established, which was supported by the circumstances that the respondent's conduct was made. They were made whilst the respondent was an Australian legal practitioner. They were made in connection with the practice of law as they referenced the respondent acting for a client in relation to a criminal law matter, and include specific details about the matter. They fell short of the standard of competence and diligence that a member of the public is entitled to expect of a reasonably competent Australian legal practitioner. In fact, The conduct does not involve a substantial or consistent failure, nor does the conduct violate or fall short of the standard of professional conduct observed or approved by members of the professional, as to be categorized as PM. The particular factual circumstances support the conclusion that the conduct arises out of a single failure to recognize the relevant Facebook post fell short of the requisite standard expected of a reasonable, competent Australian legal practitioner. While the Facebook posts were made over a period of more than 2 weeks and are not of a single isolated occurrence, the conduct is not properly categorized as a consistent failure for the purpose of the conduct amounting to PM. It is also known that the respondent concedes his conduct contravening to the rule and constitute UPC before the tribunal, which could influence the decision of UPC.
In comparison to the cases we studied before, Buckley and Counsel of the Law Society of New South Wales shows that the respondents lack insight and understanding. Ms. Buckley did not recognize how his conduct were against his professional responsibility. His responses and submissions did not address the seriousness of his conduct. This is different from the case of Differin, who showed remorse and admit his conduct, which could influence the decision of the UPC. In the case of David Lander and Counsel of the Law Society of Australia Capital Territory, the Supreme Court upheld Lander's appeal. They noted that a solicitor's duty to represent his or her client's interests forthrightly and without fear or favor is important and should be raised in the client's interests as well as generally. In contrast, Differin's Facebook post was unnecessary and not in the client's interests compared to the lender's situation. In response to the decision, the tribunal ordered that the respondent to be publicly reprimanded and to pay a pecuniary penalty. Lastly, the respondent to pay the LSC's cost of the discipline application. Regarding the orders made by tribunal, there are 3 objectives in arriving the appropriate sanction. They were not for punishment of the petitioner, but for the protection of public. Respectively, they work to maintain and enforce proper standards in the profession. They also impose personal deterrence for the respondent, and general deterrence by reminding petitioners that, as officers of the court, they must exercise vigilance when using social media. In terms of the mitigating factors, the tribunal considers the respondent's personal matter impacting decision-making, including his coping mechanism of overconsumption of alcohol, the impact of the special needs of his daughter, and his PTSD. The respondent has also shown remorse and acknowledged in oral submissions that he is deeply ashamed and has brought shame on his family. The respondent also indicates that he is currently assessed with his daughter's special needs, rather than working as a legal practitioner. The financial impact of any pecuniary penalty in these circumstances has a greater impact on him. Both personal and general deterrence were also made after considering mitigating factors, including that the risk of the conduct reoccurring is low, the need for the protection of the community is also low, and the need for personal deterrence is also relatively low.
Now to consider the behavioural ethics involved in Dufresne's case. Dufresne had a number of disablers that potentially led to poor ethical decision-making. The tribunal acknowledged several mitigating factors, including an admitted overconsumption of alcohol, a daughter with special needs, and diagnosed PTSD. Additionally, he had a history of professional misconduct, having been found guilty of 2 counts of engaging in legal practice without holding a practicing certificate in 2015. Applying these disablers to Reston Breakey, these factors could have impacted Dufresne's ethical behaviour at a number of stages. Dufresne may have simply shown a lack of awareness that posting on his client's photos may have led to a breach of confidentiality. With all the other stresses in his life, particularly suffering from PTSD and having a child with high needs, he may have been suffering from compassion fatigue, impacting his ability to recognise posting on Facebook as a moral issue. There is an obvious breakdown in Dufresne's judgment and his ability to maintain professional relationships. Certainly alcohol overconsumption could have played a role in this misstep. Dufresne's moral motives may have been, in Dufresne's mind, in the best interest of his client and made with genuine care. In one of his posts where he identified Mr. Cusack as a client, Dufresne was asking for Cusack's friends to go check on him as his phone had been taken away. He was not acting in self-interest nor to promote his services, but in a misguided approach to supporting his client. Dufresne's moral character and competence is clearly at question here. While his intentions may have been coming from a place of care for his client, he did not have the moral character or competence to put into action or achievement good ethical behaviour. Having already been found guilty of PM, he clearly lacks the ability to apply professional standards to situations. The Facebook post occurred over the time period of 2 months. In that time, Fraine had gone through the stages of moral decision-making each time he posted, and reviewed that decision as one he was able to make again. The disablers in his life may have impacted his ability to morally reflect on his behaviour.
Here's coming to our GVV and the implication part. In this context, it is possible to overlook a lawyer's responsibilities and the legal ethics during such everyday routines. So it is easy to switch from the left-hand side of the duties to right-hand side of the life, just like the slide presented. When we break down the facts, it can simply be seen as a person that is different, noticing his client, a father who is depressed and afraid of being apart from his children's childhood due to the uncertainty of the upcoming proceedings. So, Diffran wants to comfort his client and ease his nerves. He chooses to comment on his client's post just as many of us do for our friends. Although the comments essentially breach legal practitioner rules, we cannot regard this incident as absurd. The question here is, how can we avoid unconsciously and impulsively posting improper comments on social media? How can we guide ourselves to do the right thing all the time? We use GVV to solve the problem for different and probably the problem for all of us. First, we have been told that GVV is about speaking truth to power, but it is not simply about speaking up. We know that different has heavy burden in his family. He has a child with special needs. He also has a mental disorder. Not to mention he's a lawyer who has a busy everyday work. So instead of choosing to deal with those issues with alcohol, he should know there are choices and options before him. For example, he can reach out for support in the office and seek mental therapy. Even if he wants to comfort his client, he needs to comprehend the purpose and the consequence behind the action. That is giving an informed voice, not just a voice. But how do we deal with involuntary and impulsive conducts? As humans, we tend to react emotionally and automatically. Therefore, it is important to build moral muscle memory. Applying this technique in different scenarios, it is important for him to create scripts and action plans regarding his personal life to not negatively affect his professional life. For example, Diffran needs to avoid being drunk and approaching his client at the same time. Moreover, as a lawyer, if he wants to post something in public, he needs to remind himself the legal ethics all the time. It is important to practice and create those habits. Next, he can engage in peer coaching to facilitate those techniques in using social media and creating boundaries between professional life and personal life. Finally, he should try to practice and enhance those scripts and action plans. Once he has completed the process of building moral muscle memory, it will frame him to do the right thing. That is a default to an informed voice. Finally, as a legal practitioners, sometimes we forget how much impact we have. Therefore, it is important to identify stakeholders. In this case, Diffran only saw his client, but he ignored other parties who might be influenced. They are the colleague, court, the client's ex-wife, the client's children, and most importantly, the public. If he had noticed that multiple parties would be involved, perhaps he would have chosen to direct message his client or comfort his client through phone or face-to-face. Here are some recommendations implicating from this case. First, for the employer, we recommend them to make a social media policy to regulate employees' behavior on social media, also providing training for the junior lawyers and to conduct regular workshops for enhancing the enforcement of the policy. Moreover, it is important for them to check employees' mental status regularly, create a speaking up environment, and provide resources of mental support for the employees. For employees, indeed, they need to follow the social media policy, aware the boundaries between personal and professional life, and reach out for help when they need it. In conclusion, navigating the ethical landscape of social media requires conscious effort and a commitment to professional values. It is important for lawyers to uphold their responsibilities and maintain integrity in both professional and personal life. Thank you.